will be read on the Senate floor tonight at 7 p.m. We're just learning Supreme Court Justice John Roberts will not preside over former President Trump's Senate impeachment trial. Instead, it will be Senate President pro tem, a Democrat from Vermont, Pat Leahy. The trial is scheduled for February 8th. Joining us with some legal analysis is constitutional law attorney and GOP strategist Amir Benno and distinguished professor at Touro College, Thane Rosenbaum. I'll start with you, Thane. If the Chief Justice does not preside over this, does it count? I mean, there are a lot of people asking whether this is even constitutional to be able to try someone who is no longer president.
Bob, these are all very good questions. If the Chief Justice of the Supreme Court is not sitting as the judge, that demonstrates yet again that we're not prosecuting a sitting president. We're prosecuting a private citizen. And secondly, let's not forget the jurors in this case are not unbiased. They are essentially the victims of this crime. So this is not as if there was a jury of his peers sitting impartially. The argument is that the riot was being incited for the purposes of threatening and intimidating United States senators. It would be like a shoplifting case where the shopkeeper and the cashiers were all jurors.
Amir, there's been some back and forth today over the past week as to whether or not there is precedent for this to be happening at all. So is there or is there not precedent?
There is precedent. It's a bit of a mixed bag. It doesn't involve a president or a former president, but there have been officers who have been impeached after they've left office. At the end of the 1700s, there was a senator who was expelled by the Senate, and then he went on to be impeached and tried and acquitted. And then 100 years later or so, there was a Secretary of War who tried to avoid impeachment by resigning.
Yeah, that's the one they're saying specifically it can be related back to, or justifying doing this to a former president.
Well, they don't make a distinction in Senate precedent between whether it's a senator or a judge or a Secretary of War or a president. So, I mean, there is a school of thought, there are legal arguments that this can be done, that there's also a contrary school of thought that this is unconstitutional. And I think both of them have merits to them. Ultimately, the decision is going to be the Senate's to decide. They're going to get the case. You're going to need 51 of those senators to decide whether they have jurisdiction, and they can set the rules for themselves. And so the question is, who will be able to muster the 51 votes? There's a good reason why the Republicans wouldn't want it to go forward, and there's good reason why the Democrats would want it to go forward. And I think it's all about preserving the Senate majority in 2022. I think that's what this is about. They want to split the Republican Party. Yeah. They want to ensure that they have a Senate majority in 2022. And so my prediction is that they're going to vote over 51 senators to go forward with this trial.
Thane, there was a ruling by the Supreme Court regarding charges that President Trump was violating the emoluments clause. In other words, making some money that he should not be making as president. And the Supreme Court said it's a moot point. It's no longer president. Does that give us any heads up on what's to come on this? But can someone review what the Senate does? In other words, the Constitution says that the Chief Justice sits on the trial. But if that doesn't happen, can that be challenged to the Supreme Court? Does anyone review it?
Well, very good points, all of them, Bob. First of all, you're right. I think the Supreme Court in this emoluments decision was winking at the Senate and the rest of the country to say a former president is a former president. He's a private citizen, and acts that he may have engaged in, although may be criminal at the time that he was president, cannot be pursued as a private citizen. And so therefore it's moot. If the emoluments issue is moot, so too might be the president's engaging in political advocacy. Remember, the president is being prejudged as having completely urged his supporters to storm the Capitol. That's what CNN and New York Times literally reported over the weekend. that he literally directed them. But the facts are not there. There's a legal and factual issues here that are not self-evident, and the president retains a constitutionally protected right to engage in political advocacy. And I would say to the both of you and to the NewsMax audience, you know, he's had 5 years of rallies in front of thousands of people that did not result in violence. And he kind of talks this way. This is the way he talks. It's not just political advocacy, it's his style of political advocacy. And in no way did he expressly direct his supporters to smash windows, occupy offices, and intimidate senators.
So, Amir, based on that, and then just based on the Constitution and that type of argument, should President Trump's, or the former President Trump, should his attorneys just move to dismiss from the very beginning, or would it be wise for them to try to put on some sort of case to show the American public that he was not, in fact, not guilty of these charges?
Now, Thane is totally right. I mean, they should move to dismiss right from the outset. And perhaps that's what will happen. This was constitutionally protected political speech. The standard is the speech likely to cause imminent harm? If he's given these types of speeches on multiple dozens of prior occasions, and this hasn't happened, it undercuts the argument that it was likely on this occasion to cause the harm that it did. So those are factual arguments. There's legal arguments, and of course there's the constitutional argument that this kind of trial of a private citizen is not warranted under the Constitution. I said before, there's two schools of thoughts, but they would be remiss if they didn't push that argument and hopefully get a majority of the Senate to agree with them. To Bob's point, the fact that there's the Chief Justice is not presiding doesn't nullify this process. It's been done in plenty of cases where there have been judges who've been impeached, where they've had the president pro tem or the vice president sitting as the presiding officer. So I don't think that would be the concern. What would happen ultimately is if he is convicted and they vote to remove him or disqualify him, and then he wanted to run again in 2024, it would be at that point in time that he could bring a legal challenge in the courts.
Oh, okay.
And the courts at that point would have to evaluate whether this was a proper impeachment or not.
Interesting.
Before that, it would be premature.
All right. Well, Amir and Thane.
Do we get any credit for this?
Yeah.
Will this be on the exam?
Learning a lot. Yes. Well, you know, it is a lesson.
You guys make it easy.
I mean, Americans need to know how our system works. So hopefully that's one good thing that's coming out of all this. Thanks for joining us. And we'll be back with more of American Agenda right after this.